second day of the Rule of Law Convention. We are in the working session 5. This is the Rule of Law, Economic Progress, the challenge of creating independent and efficient regulatory mechanism. May I now invite Sri Lalit Bhashin, the Vice President of the Bar Association of India and the President of the Society of Indian Law Firms, to chair the session. May I request Sri M.S. Prasad, Senior Advocate, Joint General Secretary of the Bar Association of India, to come over to the dais. I request Sri Rupinder Singh Suri, Senior Advocate, former President, Supreme Court Bar Association, to come over to the dais. May I request Sri Surjit Singh Bhalla, eminent economics, to come over to the dais. Sri S.S. Naganand, the Senior Advocate, to come to the dais. I request Sri Lalit Bhashin now to chair over the session.
Thank you, Mr. Tripathi. Good morning to all the delegates, the young friends, ladies and gentlemen. I welcome Mr. M.S. Prasad, who is the co-chair for this very important session. Mr. M.S. Prasad, he is a doyen of the bar coming from Andhra Pradesh, having had his seat of practice in Hyderabad. But now, as I said, he's become national property because we see him in Delhi very often and as a senior designated advocate of the Supreme Court and the Andhra Pradesh High Court. You will be hearing from him as co-chair during the proceedings and also the final summing up of the proceedings. I have my very distinguished friend, Mr. Rupinder Singh Suri, senior advocate, practicing in the Supreme Court of India. He has held various positions in the Bar Association, including being the president of the Advocates on Record Association of the Supreme Court and a veteran leader of the Indian Bar. He's a very distinguished lawyer, and it's a privilege that we are sharing this dais with such a distinguished person as Mr. Suri. We have the presence of Mr. S.S. Naganand. Mr. Naganand is a senior advocate practicing in the High Court of Karnataka and also in the Supreme Court of India. He is the chairman of the Jurist Commission, that is the India chapter of the Jurist Commission. And it's a rare combination that he is also a chartered accountant turned lawyer, that is for the benefit of the legal profession, so that he can use practice since 1998. And we have our session coordinator, my young friend, Vibhu Prasad Tripathi, is a member of the executive committee of the Bar Association of India representing Odisha. I'll introduce Mr. Bhalla when he joins us. So friends, as you are aware, and I must recognize the presence of our president, Mr. Anil Diwan, and the dynamic secretary of the association, Mr. Prashant Kumar, Mr. Yakesh Anand, the additional joint secretary, and all other office bearers as well. Friends, we must compliment Mr. Prashant Kumar and Triveni Potekar for having put in this momentous conference on rule of law. This conference has now been institutionalized in the sense that we are having it every year. And the entire team, of course, under the guidance of Mr. Anil Devan, but mainly due to the efforts of Prashant Kumar and his team, they have done a wonderful job for hosting this 2 days of conference and interaction from all over the country. And also particularly with the law students who have come from different institutions, because after all, you are the ray of hope. When we talk of rule of law, yesterday we had a lot of discussion on rule of law and also on the judicial appointments. But when we speak of rule of law, we speak about it with a sense of some disappointment so far as India is concerned. We do have rule of law in the country because we have a very good dynamic constitution which ensures that there should be rule of law. But is there rule of law in practice? Except in certain spheres that we have elections regularly, without fail, at the center level in the parliament, at the state level, in the assemblies, and we have by far and so far a good judiciary. Other than that, what is our track record? Our track record is lack of governance, rampant corruption, declining standards in public life. This is our track record. Therefore, having some introspection, can we say that there is a meaningful, effective rule of law in this country? We are proud of our election system, we are proud of our judiciary, but we thought that Satyam episode was an aberration, that it would not happen again. But soon that has been followed by 2G scam, the coal scam, and so many scams are happening everywhere. Possibly some are in the offing. But despite that, you have seen that there has been some economic growth. So despite all this handicap, the economy has improved, at least till lately. Why is that so? Is it because of the rule of law that we have? I would say no. It is because of the inherent strength of the Indian economy and the potential for growth which is there in India, which has not yet been tapped, you see, even 10%. We are rich in resources. Just imagine if we did not have these aberrations, we didn't have corruption, we did not have red tapeism, we did not have these delays in clearance of various projects. I think our rate of progress would have been not less than about 10%. And now we are having about between 4 and 5%. So despite all these, our economy has the strength to grow. And that is where the role of the legal profession also comes in. Because economy cannot progress unless there is legal support. Legal support means you may like to enter into bilateral agreements with various powers, you see, with the US, with Japan, with Singapore, with France, UK. But then, who is there to draft those agreements? Those are very crucial, important documents. And who is there to draft such agreements? That is only the legal profession, the lawyers can do. Therefore, rule of law, when it is read in the context of economic progress, is dependent upon a very important and significant role to be played by the legal profession. We are seeing in the name of economic growth so many new laws being passed. We had the very recently, about 10 days ago, the Companies Act, when it got the seal of approval of the President of India, we have comparatively a new law on competition. There is a setting up of the Green Tribunal in the country, a comparatively new law on conciliation and arbitration, 1996. In a way, one could say that there has been tribunalization of justice in this country. The powers which were to be exercised by the high courts and the Supreme Court are sought to be transferred to these tribunals. At the drop of the hat, we have tribunals, we have regulators, little realizing that the more tribunals or more regulators you have, there are bound to be more disputes leading to arrears in the high courts, in the subordinate courts, and even in the Supreme Court. I, for myself, I am a firm believer in more of self-regulation than being regulated from the top. I think we should give some freedom to our industry and business to enable them to self-regulate. There are organizations within the industry. The industry themselves, they set up such organizations to control and monitor the activities of their members. I think such an approach should be encouraged. We already have too many laws, outdated laws, lopsided laws, overlapping laws. What is required is rationalization of laws. Therefore, a study has to be conducted that the laws which were framed in 1800 something or early 1900s, and they have been continuing, you see, all of you are familiar, even the students are familiar, you see, when our CPC, when our law of evidence, when our Indian Penal Code, criminal procedure, the Contract Act and all, when were they brought into existence. What is now required is to keep in pace with globalization and the contemporaneous developments taking place, that there should be rationalization of laws. With these few introductory remarks, I would now request my co-chair to say a few words. Okay, later, there. I would request my dear friend and colleague, Mr. Rupinder Singh Suri, Senior Advocate, to please make his presentation. Mr. Suri.
May I first of all thank the chair, Mr. Lalit Bhasin, for saying very kind words about me. Mr. Bhasin, Mr. Prasad, Shri Anil Devanji, Mr. M.S. Prasad, Mr. Naganan, Bibhu, Surinder. It's a very thought-provoking topic. And the topic runs like this: strengthening institutions to meet current challenges. What are these institutions and what are these challenges? I think let's start from fundamentals. Institutions are the institutions as have been envisaged in the Constitution of India, since sovereignty is going to be exercised through institutions. Constitution is supreme. Exercise of sovereignty is as per the basic features set out in Constitution, and it has to be done through institutions. What are the current challenges? Current challenges are all those obstacles which come in our way of not achieving our objectives as given in our preamble. Economic justice, social justice. It basically entails that you must have growth and you must have distribution and a distribution based upon equity and equality. Equality of opportunity should also be there. And equality should not be on paper, it should be really meaningful. Now, challenge of today of institutions is that our institutions dovetailing with each other for achieving the objectives given in directive principles, given in preamble, or they becoming obstruction into each other. We have to ensure that obstructions don't come in the power that the institutions would exercise. And strengthen means, in that sense, that they must exercise it, knowing full well their powers, and exercising within that parameter which is given to them. Now, Mr. Lalit Bhasin mentioned about lopsided laws, about antiquated laws, about overlapping laws. I'd like to go back. It was there yesterday also, it is there today also, and will continue to be there even tomorrow also, irrespective of all the revisions of law and rationalization. Why does it happen? We have to go back to the dialectics. That is, man acts on the nature, correspondingly nature acts on the man, the productive forces grow. And productive potential grows to an extent that is unimaginable. Growth of centuries is being limited into growth in decades. Growth of decades is being limited to growth in years. Growth of years in matter of months. Months growth in matter of weeks. And weeks growth in matter of hours. That's how the things are happening. And a very beautiful, I need not go into this, the Toffler's Future Shock and the two sequels thereafter are very, very relevant as to what things are going to happen. Now, when the productive forces grow, they are governed by productive relations. How do you govern those? When you start governing that, a dichotomy comes, a disharmony comes between what you are trying to do and how you are going to do. And therefore, laws are always a step behind than what the economic growth is taking place. Topic is very relevant, which reads, rule of law and economic progress. That's the essential thing. I'm not going to speak on rule of law. You have heard about it enough yesterday. And you have also seen the distinction between rule of the law and rule by the law. If law is going to lag behind, then sagacious leadership requires to anticipate the change and to be in a position so that changes and progress are smooth and they are not disharmonious. Fortunately, we don't have to invent the wheel every time because certain countries have gone through this process and we can learn very fast. But today, regulatory mechanism is one of the main reasons which attracts investment or distracts investment. Regulatory regime in India is not supposed to be that conducive. It has been applied in certain selective sectors, but it is not uniform across the other infrastructure sectors. And thereby, the response of the investment to this hasn't been that positive as it can be. Potentiality is tremendous, as Laliji says. Notwithstanding anything else, rule of law was there or not there, it has come up to this stage. One of the things that we were selling to the world at large and we believed is that yes, our judiciary is very good. But what's the fun of a judiciary if it delivers in 10 years, 15 years and 20 years? Justice must be done swiftly, justice must be done demonstratively, and I think that's an inbuilt thing about the rule of law in this particular situation. Now, judges are realizing that Constitution may think that they know everything, but ground reality is that they don't know everything. Such complicated issues are coming where a judicial mind, when aware of two sides, can come to a right conclusion. But it cannot work in swift manner. If there is so many important issues lying down before the Supreme Court or High Courts and others, the economic growth will stall if we keep waiting for that kind of decisions. Therefore, out of necessity, the need for tribunals came in. So in 1976, you had introduction of the tribunals, Part 14A, 323 and 323B, which itself envisaged that we must have tribunals.